This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we speak about when an insured withdraws a claim. The insurer should understand that there's no need to sue for declaratory relief, and that when you win, it's best to just shut up and accept it. As a young lawyer, one of the first things I learned was never argue with the judge whose tentative ruling is to grant your motion. Sometimes you convince him to go the other way. Insurers often seek, when there is a dispute of insurance coverage, that a court grant declaratory relief about the duty to defend or indemnify an insured. However, when there is no claim, it is a waste of the time of counsel, the insured, and the courts to bring a declaratory relief action. The axiom to never argue over a win was explained by the United States District Court for the Eastern District of Virginia in Hanover Insurance Company versus C. David Venture Management et al., a August 30, 2022 decision of that district court. Hanover sought a ruling it owed neither defense nor indemnity to the defendants. The defendants, David Venture Management LLC and Venture Street LLC, moved to dismiss the Hanover American Insurance Company lawsuit because it was not justiciable. The lawsuit for declaratory judgment implicates Hanover's potential duties to defend or indemnify the defendants in a putative class action brought in the U.S. District Court for the District of Colorado. Beginning on December 9, 2017, Hanover issued the first of several commercial general liability policies to the defendants. Hanover also issued commercial follow-form excess and umbrella policies for the same effective dates. Defendant Venture Street was added as an additional named insured on the CGL and excess policies in May of 2019. Plaintiffs in the putative class action styled In Re Home Advisor Inc. litigation, they filed suit in July of 2019. The plaintiffs in the Home Advisor lawsuit amended their complaint several times and continue to assert claims against the defendants. After the defendants were named in the Home Advisor's lawsuit, they provided notice of the litigation to Plaintiff Hanover. On November 12, 2019, Hanover responded to the notice by denying defendants insurance coverage for the Home Advisor lawsuit. Defendants sought reconsideration from Hanover on January 29, 2020, and again on April 23, 2021, but Hanover reaffirmed its coverage denial. Plaintiffs filed suit on July 6, 2021, seeking a declaration that they owe no duty to defend or indemnify defendants in the Home Advisor lawsuit. Plaintiffs maintain that there is no coverage available for the claims asserted against the defendants in the Home Advisor lawsuit for multiple reasons. Specifically, plaintiffs allege that insurance coverage is unavailable because the claims do not allege damages because of bodily injury or property damage caused by an occurrence within the meaning of the CGL or excess umbrella policies. The claims do not allege damages because of personal and advertising injury within the meaning of the CGL policies. The claims do not allege damages because of advertising injury or personal injury. The alleged acts were not committed and the alleged injuries did not occur during the relevant policy periods, and several exclusions bar coverage, including exclusions for expected or intended injury, knowing violation of the rights of another, infringement of copyright, patent, trademark, or trade secret, insureds in media and internet-type businesses, and personal and advertising injury. Defendants, in response, notified the plaintiffs they were no longer seeking coverage from the plaintiffs for the Home Advisor lawsuit, and they did so on July 19, 2021. Yet, with that information on August 16, 2021, defendants affirmed that they had withdrawn their request for coverage from Hanover. Through counsel, defendants communicated the details of their withdrawal to the plaintiffs, yet the lawsuit was filed and continued. The Declaratory Judgment Act authorizes federal courts to review claims for declaratory relief. The animating purpose of a declaratory judgment remedy is to guide parties in their future conduct in relation to each other, thereby relieving them from the risk of taking undirected action incident to their rights. The doctrine of standing is grounded in the Constitution's limits on the Article 3 judicial power. Ripeness, another justiciability doctrine, determines when a case or controversy is fit for federal judicial review. A claim is not ripe for adjudication if it rests upon contingent future events that may not occur as anticipated, or indeed may not occur at all. A declaratory relief action is only ripe for judicial resolution when the facts alleged under all the circumstances show there is substantial controversy between parties having adverse legal interests of sufficient immediacy and reality to warrant the issuance of a declaratory judgment. Plaintiff's complaint seeks a declaration that Hanover owes no duty to defend or indemnify the defendants in the Home Advisor lawsuit. However, defendants have already notified the plaintiffs they were withdrawing their claim for insurance company coverage related to the Home Advisor lawsuit. The facts of the case do not call for declaratory relief on either the duty to defend or the duty to indemnify questions. Critically, defendants no longer seek coverage under the relevant insurance policies for defending against the Home Advisor lawsuit. As a result, there is no live question regarding plaintiffs' duty to defend in that litigation. If plaintiffs do not deny defendants coverage in defending against a potential future amended complaint in the Home Advisor lawsuit, defendants, or if defendants never again seek such coverage, then a decision from the court concerning plaintiff's duty to defend will have no effect. Were the court to interpret the relevant CGL and excess umbrella policy language regarding a duty to defend at this juncture, such a ruling would be premature and therefore tantamount to an advisory opinion in contravention of Article 3 of the U.S. Constitution. Similarly, plaintiff's duty to indemnify the defendants under the relevant CGL policies is not ripe for resolution. Whether defendants should be indemnified by plaintiffs against liability for injuries would depend in the first place upon whether defendants are found to be liable for the conduct alleged in the Home Advisor lawsuit, but that question cannot be answered at this time. Thus, the court cannot at this time exercise its prerogative under 28 U.S.C. Section 2201 to issue a declaratory judgment on the indemnity question. Defendant's motion to dismiss, therefore, was granted, and plaintiff's complaint was dismissed without prejudice, allowing them, if they desire, to file an amended complaint, although It will probably be another waste of time. In my opinion, Hanover denied defense and indemnity to the defendants on proper grounds. And those defendants who, after some discussion, agreed and withdrew their claims with no claim pending, only a potential for a future claim, Hanover refused to accept the fact that it had won the argument about the availability of coverage for defense and indemnity and filed a complaint for declaratory relief, seeking the order of the court that the decision of the defendants not to seek defense or indemnity was correct and preventing them from changing their mind, therefore making their insureds litigate a question that was not ripe or even pending. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone at zalma.com/blog. If you found this video to be interesting or useful to you, please tell your colleagues so that they can also view the video, read the blog post, or subscribe to the blog. Thank you for your attention.